children that are 12 years old and older should have the opportunity to speak. I think the presumption should be that they have the right to speak to a judge. If there are extenuating circumstances that would make that inappropriate, then one of the parents can bring that information before the judge. Children under the age of 12 will not have the presumption, but even those could potentially be allowed to speak to a judge in circumstances where there are clinicians and other people who have been working with the child who will say this child is mature enough to speak, and this child really feels that they need to be part of the process. We've had a lot of controversial cases recently about parental alienation and high conflict cases where judges have specifically refused to interview children, saying, well, we know what they're going to say because they've been programmed by one side or another. Well, the reality is, even if they've been programmed, that is what their experience is about. The judge should know about that. The judge should know how they're feeling, and the judge should know how their decision is going to impact these children and not ignore them. The opposition to judicial interviews comes from various sources. One opposition comes from the judges themselves, where they think that they're not qualified to do it, where they feel that they might not be comfortable in doing it. And the answer to that is, well, we need judges who are knowledgeable, comfortable, and experienced in doing that, and I think that will resolve that issue. Those who argue that this is going to put the children in the middle, and I appreciate that argument, the reality is that the cases that go to trial, I'm not talking about kids being interviewed in just any case, the cases that go to trial, these children are already in the middle. We are deluding ourselves if we think that these children are not being manipulated by their parents. And therefore, if they're going to be in the middle, isn't it better for them to come front and center and to be able to talk to the decision maker? There are some objections from people who will say that if we do this, then it's going to lead to parents even being more involved in trying to program the children as to what they should say to a judge. I don't think that things can get worse. All we have to do is read some of the latest decisions on high conflict cases as to what parents are doing. I think it's a question of how you do it. And by the way, this is not really a novel idea. They've been doing it in the Netherlands and in Israel and in the United Kingdom and just not that far from here, Ohio and New York, they do it. So it's done elsewhere. They've been able to find a way of doing it without creating problems and enhancing the life of the children. Why can't we? The message I really want to get out is that children have human rights, that when we make decisions affecting their life, that they, if they're old enough and mature enough, should be able to express their opinion and participate in the process.